In this lecture, we shall discuss the human rights. Now, the fact that human rights issues and discussions have confronted a lot of countries across the world today is not in dispute. As a matter of fact, the recognition and enforcement of fundamental human rights is one of the chief pillars of the United Nations. So ever since the United Nations was established, more particularly after the end of the Second World War, many countries across the globe have all taken frantic efforts to ensure that human rights are guaranteed and recognized across the globe. And therefore, there are some minimum yardsticks for which we can measure and infer the existence of fundamental human rights. But in order to set the discussion about human rights in a better perspective, we must begin by defining what human rights are. So how do we define human rights? What are human rights? Now, there are several scholars that have all taken the pain and time to define what human rights are. Within our Ghanaian context, I will make reference to the definition that has been proffered in the book titled A Handbook of the Constitutional Law of Ghana and Its History, written by Sir Kofi Kumadu. Now, this is how the learned author defines human rights. And I quote from page 209 of the book. And I'm quoting now. Basically, human rights refer to claims or demands that we make of the state and our fellow human beings to enable us to live our lives in decency, security, and with dignity. They are norms, standards, or attributes of our humanness guaranteed or recognized and not granted by a constitution at the domestic level and human rights instruments at the international level. They therefore define or relate to our humanity. Human rights are about the human being. They are about human issues. Since human beings are complex, human rights issues sometimes reflect this complexity. But they are the contemporary world's major standard for separating civilized countries from primitive ones. Again, they are the contemporary world's major standard for separating civilized countries from primitive ones. Concern for them transcends national borders, cultural diversities, and levels of economic, industrial, or technological advancement. Full stop. Quote ends. So, if you look at the definition given by Sir Kofi Kumadu, we are recognizing that human rights are the claims that enable the states and our fellow human beings to enable us live our lives in decency. They enable us live our lives in dignity, and they enable us live our lives with security. So if you have any practice that is an affront to the dignity of a person, then we can say that it is an affront to the person's fundamental human rights. If you have a conduct that is strictly violating a person's decency, we can say that it is violating a person's fundamental human rights. If it is exposing the person to reckless insecurity, we can say that it is in violation of the person's human rights. Another interesting thing that we have to note about the definition given by Sir Kofi Komando is that he says that they are norms, standards, or attributes of our humanness, guaranteed or recognized, then he puts into bracket, not granted by a constitution at the domestic level. What I want us to pay attention to is the use of the expressions that they are guaranteed or recognized, but they are not granted by a constitution. By the constitution, but they are rather guaranteed. If they are guaranteeing it, it means that we are guaranteeing their existence. So, human rights provisions are guaranteed or recognized, but they are not granted by the constitution at the domestic level. But at the international level, it says that they are guaranteed by human rights instruments on international level. So he says that the human rights provisions are guaranteed or recognized by the constitution at the domestic level, and they are guaranteed or recognized by human rights instruments at the international level. Then another interesting point he makes is that human rights are the contemporary world's major standard for separating civilized countries from primitive ones. It means that if there's a country that is always violating the human rights of its citizens, then it will be very difficult to refer to that country as a civilized country. So Sir Kofi Komabo says that they are the contemporary world's major standard for separating civilized countries from primitive ones. That is a very interesting definition of human rights that we must all embrace. Now, apart from Sir Komado's definition of what human rights are, it is important that we also take a look at another scholar, Jando. Jando delivered a paper at the Bangkok World Conference on World Peace Through Law in 1969 on the topic, the constitutional protection of human rights in developing nations. The constitutional protection of human rights in developing nations. And this is what the learned author also said about human rights, and I quote, "Human rights are freedoms which enable us to live our lives, our natural lives, in decency and security, avoiding, so far as human weakness can, the sorrow and tribulations that come from greed, cruelty, or prejudice, or as often as not, from mere thoughtfulness, apathy, or even tranquil acceptance of the inadequacy of other men." Then the quote ends. He says that it is the freedom, that human rights connotes the freedom that enables us to live our natural lives in decency and security. So you can see that it is common in Sir Kofi Komado's definition that human rights are the claims or demands that we make of the states and our fellow human beings to enable us live our lives in decency, security, and with dignity. And in Jando's paper as well, he says that human rights are the freedoms that enable us to live our lives in decency and security. So it means that if there are practices that violate a person's security, they violate a person's decency, they are subjecting you to torture, they are subjecting you to extreme indecency, then we can say that they violate a person's human rights. And so, having gone through the two definitions by the scholars, We shall now proceed to look at the three common values that underpin human rights. The learned author Sir Kofi Komado identifies that human rights involve three sets of values. It means that if you have to understand the whole of human rights, it is good that you look at three sets of values. Those are the three values that animate and underpin human rights. So the learned author identifies the following three as the values that animate human rights. One, values or attributes which free us from the violation of the integrity of our physical being, either by government or our fellow human beings. Again, one, values or attributes which free us from the violation of the integrity of our physical being, either by government or of our fellow human beings. So it means that we are looking at attributes which will free us from violation of the integrity of our physical being. What are some of the things that can violate the integrity of our physical being? Torture. Torture, if they are torturing you. Torture is something that violates a person's physical being or his integrity. Again, subjecting a person to degrading treatment or punishment. If it is punishment and then they strip you naked in public and they are flogging you, this is something that is also inimical to your physical integrity. Or what is another thing too that can violate a person's physical integrity? If you also have things that are preventing you from having freedom of conscience or freedom of religion. Every person, we are supposed to have our freedom of conscience. So there's a practice that is preventing you from having your freedom of conscience and freedom of religion, then that will also be a violation of our physical integrity. So Sir Kofi Komado notes that one of the three values of human rights are that values or attributes which free us from the violation of the integrity of our physical being that is done by either the government or our fellow human beings. Number two, he identified human rights to involve values which enable us to satisfy our vital needs of food, water, shelter, healthcare, a healthy environment, and education. To realize vital needs, we need leadership from government. So he says that if we discuss human rights must definitely have values that will enable us satisfy our vital needs of food, water, shelter, healthcare, a healthy environment, and education. So it means that if you are supposed to draft laws that would advance and promote people's fundamental human rights, you must make sure that the laws you draft that are for the purpose of advancing the people's fundamental human rights, those laws must have values which enable us to satisfy people's needs of food. It must not be something that is going to prevent people from farming. It must not be a law that will prevent people from eating food. If you do that one, then you're not reflecting human rights. It must be a law that is allowing people to have their means of shelter. It must be a law that is allowing people to have healthcare needs, to take care of themselves. It must be laws that would allow people to have access to a healthy environment. Because think about it, if you live in an environment and there are laws that are promoting practices that are making the air that we even breathe inimical to our health, then we can say that such laws are an affront to our human rights. Because remember, human rights they guarantee us to live our lives in decency and with dignity. That's another value of human rights. Values which enable us satisfy our vital needs of food, water, shelter, healthcare, a healthy environment, and education. A third value of human rights. Values relating to self-management, according to Sir Kofi Kumado in his book. And there are values relating to self-management, that is to say, the opportunity to have access to and participate in the process of government. Example, the right to free expression, free media, universal adult suffrage, or free and fair elections, equality, freedom of association, the right to peaceful assembly and public protests. The realization of these values requires partnership with government and fellow human beings. So the third value of human rights that Sir Kofi Kumado identifies in his book, A Handbook of the Constitutional Law of Ghana and its History, the third value that he identifies for human rights are values relating to self-management. That is to say, the opportunity to have access to and participate in the process of government. How do we participate in the process of government? By the right to vote, right to free expression. So the right to vote, we call it universal adult suffrage, equality, freedom of association. These are means that the law is supposed to afford us to participate in the process of government. So these are the three values that Sir Kofi Kumado identifies. One is that values or attributes which free us from the violation of the integrity of our physical being, either by government or fellow human beings. Two, values which enable us to satisfy our vital needs of food, water, shelter, healthcare, a healthy environment, and education. And then thirdly, values relating to self-management. That is to say, the opportunity to have access to and participate in the process of government. In order to fully understand the concept of human rights, there are a few concepts that we must familiarize ourselves with. And I'll quickly go through these concepts. The first concepts are the concept of soft and hard law. Now, when we talk about soft law essentially refers to non-binding standards. These standards, they are not enforceable in courts of law. They are not binding, but they have been accepted by human rights activists. Usually they come in the form of declarations. So if you look at for example, the United Nations Universal Declaration of Human Rights of 1948, the United Nations Universal Declaration of Human Rights of 1948. Now, states across the globe have affirmed acceptance of this declaration, but it's a soft law. You cannot go to the court and say that you are enforcing provisions contained in the United Nations Universal Declaration of Human Rights of 1948, because these ones are not really incorporated into enforceable laws. They are non-binding, but they have gained some form of strength because of their acceptance by human rights activists. Another example of soft laws would be Sustainable Development Goals. Sustainable Development Goals. Now, some of these Sustainable Development Goals as well, they show what the state is trying to achieve. They show what the standards of states supposed to achieve, but they are not really enforceable binding documents. And then we also have hard law. Now, hard law refers to legally binding documents or instruments on human rights. For these hard laws, it means that you can proceed to the court of law to seek their enforceability. Now, the hard laws, they come in the form of conventions. You can have them in the form of protocols. You can have them in the form of charters. You can have them in the form of covenants. So, in the discussion of human rights, it is important for you to appreciate the role that soft law plays and the role that hard law plays. Remember, like I said, we are not saying soft law is irrelevant. We have mentioned that even soft laws, they enjoy universal acceptance by human rights activists. So even though we are saying they are not enforceable in the court of law, we can tell that this is soft law. And so when you do this, you are violating human rights. I mean, we can say it as human rights activists because human rights activists are committed to those ideals. Those are what we call soft law. They are not legally binding. They are not legally enforceable, but they enjoy acceptance by human rights activists. And then you have hard law. Hard law referring to legally binding instruments on human rights. And over there, we've seen examples, protocols, conventions, charters, covenants, and the like. The next concept we need to understand as far as human rights is concerned is to look at the generation of rights. Some human rights have been described as third generation rights, others have been described as second generation rights, and others have been described as third generation rights. So let me just walk you through the different categories of rights that have been categorized. First, first generation rights. Now, the rights that we usually refer to as first generation rights are the rights that relate to civil and political rights. Civil and political rights. Second generation rights are the rights that relate to economic, social, and then cultural rights. Economic, social, and cultural rights. And then the third generation rights, they are also known as solidarity rights. Now, these rights include right to a healthy environment, right to a social security, and right to control over natural resources. So, three generations. First generation rights, civil and political rights. Second generation rights, economic, social, and cultural rights. Then third generation rights, right to a healthy environment, social security, and control over natural resources. Now, one would ask, where did we even get these generations of rights from? These generations of rights were first introduced by a person called Karel Vasek. Karel, K-A-R-E-L, Vasek, V-A-S-E-K. Karel Vasek was the first director of the Division of Human Rights at the United Nations Educational, Scientific, and Cultural Organization. United Nations Education, Scientific, and Cultural Organization. It's called UNESCO. So Karel Vasek was the one who introduced the concept of generation of rights. But it is important to note that ever since we had the United Nations Conference on Human Rights, the one that was held in Vienna in June 1993, now the international community has now taken steps to now formally adopt a human rights doctrine. So now we are abandoning the prioritization of rights. So we don't want to have any prioritization of rights. That this one comes first, this one comes second, this one comes third. No. Ever since we had that United Nations Conference on Human Rights that was held in Vienna in June 1993, the international community has adopted a human rights doctrine, and this doctrine has 4 components. So we are no more looking at rights that have been prioritized. We are looking at the doctrine that has 4 components. What are the components? That human rights are universal. Human rights are interrelated. Human rights are interdependent. And human rights are indivisible. So human rights are universal, they are interrelated, they are interdependent, and they are indivisible. So we have defined human rights so far. After defining human rights, we have also looked at the 3 sets of values that animate human rights. And we've also explained some key concepts about human rights. We've explained soft law, we've explained hard law. We've also looked at the generation of rights, and you've seen the 4 components of human rights that we've now had after the United Nations Conference on Human Rights held in Vienna in June 1993. The next thing is to point out, now that we know what human rights are, we know what the definition is, we know what the values are, it is important to make the point that human rights remain a component of rule of law and constitutionalism. For those who have already studied rule of law and constitutionalism, you remember that we have mentioned that human rights, recognition of human rights is a component of rule of law and also a component of constitutionalism. Now, before we proceed, let's now look at people that we can describe as human rights activists. We've said human rights activists. Human rights activists. Who are these human rights activists? They come in several forms. One category are non-profit organizations or NGOs. So non-profit organizations, you have them over there. You have NGOs. You also have corporate social, civil society organizations. You also have NGOs, and you also have think tanks. They are all different components of people that fall within the category of human rights activists. You have the non-profit organizations. You also have the civil society organizations. We also have think tanks. And then we also have NGOs. So remember all of these as far as the activists, human rights activists are concerned. Now, at this point, let us look at the human rights regime before our current 1992 constitution. The human rights regime in Ghana prior to the current 1992 constitution. How has our history books captured the recognition and enforcement of fundamental human rights prior to the current 1992 constitution of Ghana? The first constitution I will start with is the 1960 Republican Constitution. That is the first Republican Constitution of Ghana. Now, when Ghana became a republic and we adopted our first Republican Constitution in 1960, it was thought necessary to have some provisions captured in the constitutional texts to regulate the recognition and enforcement of fundamental human rights. The first case that we can look at is the case of Re Akoto. Re Akoto and 7 others is reported in 1961, Ghana Law Reports at page 523. Now, the key thing that we need to note about this case is that it related to the Preventive Detention Act, which gave the first president of the Republic of Ghana the power to detain some persons without trial if the president considers their conduct to be prejudicial to the security of the state. So the persons in this case had been detained pursuant to the Preventive Detention Act. The Preventive Detention Act, which permitted the president to detain persons without trial. Now, amongst the many issues that came up in the courts, one of the grounds was that Preventive Detention Act that allowed the president to detain persons without trial. It was argued that the act was invalid because it was repugnant to Article 13 of the 1960 Constitution. So it was canvassed on behalf of the applicants that Preventive Detention Act that allowed the president to detain people without trial, that it was an affront and in conflict with Article 13 of the 1960 Constitution. So one would ask, what does this Article 13 say? Now, Article 13 requires the President of the First Republic, upon assumption of office, to declare his adherence to certain fundamental principles, which are, and I quote, so the president was required upon assumption of office to declare that he's going to adhere to certain fundamental principles, which I'm now about to quote, and I'm quoting now, that the powers of government spring from the will of the people and should be exercised in accordance therewith, that freedom and justice should be honored and maintained, that the union of Africa should be striven for by every lawful means, and when attained, should be faithfully preserved, that the independence of Ghana should not be surrendered or diminished on any grounds other than the furtherance of African unity, that no person should suffer discrimination on grounds of sex, race, tribe, religion, or political belief, that chieftaincy in Ghana should be guaranteed and preserved, that every citizen of Ghana should receive his fair share of the produce yielded by the development of the country, that subject to such restrictions as may be necessary for preserving public order, morality, or health, no person should be deprived of freedom of religion, of speech, of the right to move and assemble without hindrance, or the right of access to courts of law. And the quote ends. So you can see that in this quote, Article 13 is requiring the president to declare that he's going to adhere, that no person shall suffer discrimination on grounds of sex, race, tribe, religion, or political belief. So you see, the argument was that Public Order Act, that Preventive Detention Act, the Preventive Detention Act, which allowed the president to detain people without trial, it was in conflict with this Article 13(1) that allowed that required the president to declare his adherence to these principles. And one of the principles is that no person should suffer discrimination on grounds of sex, race, tribe, religion, or political belief. So the argument was made on behalf of the applicants that Article 13(1), which is similar to the coronation oath taken by the Queen in England, that it should be construed to be a Bill of Rights. A Bill of Rights in the sense of what we have under the US Constitution, which should be enforceable in the court of law. So according to the applicant, the Article 13(1) should be construed as a Bill of Rights in the sense of what we have in the United States of America, so that if it is enforceable, then the Preventive Detention Act will be deemed to be in conflict with this Bill of Rights. Because think about it, people have been detained without trial. Now, what did the court say in relation to this? I'm quoting from the dictum of Chief Justice Corsa. And this is what he says, and I quote: "This contention, however, is based on a misconception of the intent." So let me start from the top. That all grounds relied upon appear to be based upon Article 13 of the Constitution. It is contended that the Preventive Detention Act is invalid because it is repugnant to the Constitution of the Republic of Ghana, 1960, as Article 13(1) requires the President, upon assumption of office, to declare his adherence to certain fundamental principles, which are, then he quotes Article 13 and the principles. Then we go ahead, and I'm quoting: "This contention, however, is based on a misconception of the intent, purpose, and effect of Article 13(1), the provisions of which are, in our view, similar to the coronation oath taken by the Queen of England during the coronation service. In the one case, the President is required to make a solemn declaration. In the other, the Queen is required to take a solemn oath. Neither the oath nor the declaration can be said to have a statutory effect of an enactment of Parliament." I'm taking that part again. Neither the oath nor the declaration can be said to have a statutory effect of an enactment of Parliament. The suggestion that the declaration made by the President on assumption of office constitutes a Bill of Rights in the sense in which the expression is understood under the Constitution of the United States of America is therefore untenable. And the quote ends. So all that the Supreme Court is saying is that the declaration that the President is supposed to make under Article 13(1) of the 1960 Constitution, that declaration that he's supposed to make, saying that freedom and justice should be honored and maintained, that the Union of Africa should be striven for by every lawful means, and when attained, should be faithfully preserved, that no person shall suffer discrimination on grounds of sex, race, tribe, religion, or belief. The court is saying that all of these declarations the President was supposed to make, according to Article 13(1) of the 1960 Constitution, they are saying that they did not constitute a bill of justiciable rights. It means that those provisions are not enforceable in the court of law. Chief Justice Corsa said as follows, and this is more piercing. We are still on the case of Re Akoto. Chief Justice Corsa said as follows, and I quote again: "It will be observed that Article 13(1) is in the form of a personal declaration by the President and is in no way part of the general law of Ghana. In the other part of the Constitution, where a duty is imposed, the word shall is used. But throughout the declaration, the word used is should. In our view, the declaration merely represents the goal which every president must pledge himself to attempt to achieve. It does not represent a legal requirement which can be enforced by the courts." Goes ahead to say that on examination of the said declarations, with a view to finding out how any could be enforced, we are satisfied that the provisions of Article 13(1) do not create legal obligations enforceable by a court of law. The declarations, however, impose on every president a moral obligation and provide a political yardstick by which the conduct of the head of state can be measured by the electorate. The people's remedy for any departure from the principles of the declaration is through the ballot box and not through the courts. The people's remedy for a departure from the principles of the declaration is through the use of the ballot box and not through the courts. Chief Justice Corsa, this is what he says, and the quote ends. So what we are realizing is that under Article 13(1) of the 1960 Constitution, the president was supposed to make a declaration that he's going to adhere to certain fundamental principles. The court is saying that those principles are only a goal. They are his personal declaration, and they do not constitute justiciable rights. And since they don't constitute justiciable rights, you cannot seek a remedy in the court of law when the president goes ahead to breach those particular provisions. And that if you think you don't like what the president is doing, your remedy is not to run to the courts, but your remedy is to wait for election time and they remove the president from power. So all that they are saying is that the Article 13(1) of the 1960 Constitution, it does not constitute a bill of justiciable rights that will be enforceable in the court of law. This is a very key decision that you should really pay attention to. The case of Re Akoto and 7 others, 1961, Ghana Law Reports, page 523. It's a very key decision. When you understand this case very well, that this was the situation in 1960. Today, when you look at our 1992 Constitution, and then you see that we have fundamental human rights, a full chapter of the Constitution devoted to fundamental human rights, where you have Article 12 all the way to Article 33, you will know that we've come from somewhere. Because there was a time in our history as a country when in 1960, we were told that that provision under Article 13, it was merely a personal goal, a personal declaration. It was merely an oath, which was not enforceable in a court of law. So people who were detained by the PDA, the Preventive Detention Act, they could not come to the court to apply for habeas corpus to compel the president or to justify the reason for the detention. If the president likes and then he just goes ahead to detain you, you can't do FOCO and you must be there. You can't talk about human rights because the Constitution has made it just a personal declaration and it wasn't an enforceable right. So all that they must do, that's you consider your conduct to be prejudicial. They lock you up, and then that is it. And one of the very prominent people who contributed to the development of the law of Ghana and democracy in Ghana, the late J.B. Dankwa, he was also detained at the PDA. He just said that you consider your conduct to be prejudicial. They lock you up. And he even unfortunately also passed on in prison. May his soul rest in peace. That is the gravity of the situation. That is what was being used. J.B. Dankwa was part of the founding fathers of the United Gold Coast Convention Party. That was the first political party that was formed in Ghana, and it was the UGCC that was formed. Kwame Nkrumah, the first president, was initially with the UGCC, and he broke away from the UGCC, formed the CPP. Now, the very people who formed the UGCC and then brought him to the UGCC before he broke away. Now, when Kwame Nkrumah became president, then he used the same Preventive Detention Act to detain J.B. Dankwa. And then, as we have seen in Re Akoto, once you are detained, you cannot apply to the court to question the reason for your detention. It's not the court who is detaining you. President says he considers your conduct to be prejudicial. So then they're just going to lock you up, and that is it. You can't apply to any court. And when in Re Akoto they tried to do it, what was argued? What was argued? It was argued that those provisions in the Preventive Detention Act, they were not in conflict with Article 13 of the 1960 Constitution, because Article 13 of the 1960 Constitution did not create enforceable rights. Now let me just make a brief comment. You remember I mentioned that J.B. Dankwa was part of the founding fathers of the United Gold Coast Conversion Party, and he is the one who participated in engineering, bringing Kwame Nkrumah from outside Ghana to come and join the United Gold Coast Conversion Party. Now, Kwame Nkrumah broke away from the UGCC and from the CPP, and then he won elections and became the first president. Now, it will interest you to know that in the case of Re Akoto, when the people were detained without trial, it was J.B. Dankwa who acted as lawyer for the appellant, arguing that their detention was in conflict with Article 13 of the Constitution, and therefore the people should be released. So he argued forcefully that Article 13 of the Constitution creates some rights, but the court disagreed with him, as we have seen what Chief Justice Potter said, that the provisions in Article 13 do not create enforceable rights, but they only create rights. They are only mere declarations by the president, and they refer to goals that the president may achieve. And if he doesn't achieve those goals, your remedy is not to run to the courts, but to rather wait for the time for election and vote him out. J.B. Dankwa was the one who argued for the appellant. What we didn't know at the time was that later, this same J.B. Dankwa was to suffer the fate of the same Preventive Detention Act. He was also thrown into prison and passed on in prison. May his soul rest in peace. So that is how we had human rights provisions under the 1960 Constitution. Because of the experience we've had under the 1960 Constitution, I'm saying that it is important for you to know this, so that today, if you see that we have chapter 5 dealing with fundamental human rights, you will know that where we came from is a very far place. So after going to the situation under the 1960 Constitution, again, we had our next Republican Constitution in 1969. In the 1969, because of the experience we've had in the past, a major effort was made to use the Constitution to create enforceable and justiciable human rights. Enforceable and justiciable human rights, which was enforceable in the court of law by an independent judiciary that had the power of judicial review. So that was under the 1969 Constitution. And then we have the third Republican Constitution, the 1979 Constitution. The 1979 Constitution to also reproduce a lot of enforceable human rights provisions that we got from the 1969 Constitution. So under the 79 Constitution too, we had enforceable human rights provisions that were enforceable in court of law. And then after 79 Constitution, we have the fourth Republican Constitution, which is the 1992 Constitution. The 1992 Constitution. And in this one, as we have a full chapter of the Constitution, Fundamental Human Rights, Article 12 to Article 33, dealing extensively with human rights provisions under the 1992 Constitution. And so it is important for us to now delve into detail to look at the different rights. It's so important to every person that we must go through all the rights, Article 1 all the way to 33, so that you and I will know what provisions today we have as our fundamental human rights recognized under the 1992 Constitution. So, by way of recap, we have defined what human rights is. We have been able to define and explain the values, the four values, the three values that animate human rights. We said that one, there must be values or attributes which free us from violation of the integrity of our physical being, either by the government or our fellow human beings. Number two, there must be values which enable us to satisfy our vital needs of food, water, shelter, healthcare, and healthy government and education. We've also mentioned as a third value that human rights require that you have values relating to self-management. That is to say, the opportunity to have access to and participate in the process of government. So after looking at these three values, we distinguish and look at some concepts of soft and hard law. We mentioned that soft law are not binding, but they have been accepted by human rights activists. We mentioned that hard law is acceptable and enforceable in court of law. We look at the generation of rights, first generation, second generation, third generation, and we mentioned that that concept was propounded by Karol Vasek, who was the first director of the Division of Human Rights in UNESCO. And we mentioned that after 1993, we've had the international community adopting a human rights doctrine that has four components, i.e., that they are universal, interrelated, interdependent, and indivisible. We also mentioned that human rights recognition and enforcement of human rights is a cardinal feature of rule of law and constitutionalism. We explained and identified people that will qualify as human rights activists. We mentioned that we have think tanks, we have NGOs, we have civil society organizations as human rights activists, and they all contribute to the development and recognition of human rights. Then we went ahead to look at the historical accounts of how we have respected and enforced human rights in Ghana. We started with the 1960 Constitution. We look at Article 13 that required the president to make some declarations on his adherence to certain rights. And we saw how in the case of Re Akoto, the court held that the declarations to be made according to Article 13, they were merely goals that were to be attained and they did not create enforceable, justiciable rights. And so, after looking at Re Akoto, we look at the situation under the Second Republican Constitution, 1969. We look at the situation and we said over there that based on the experience we've had from Re Akoto, a conscious effort was made and then we had enforceable and justiciable rights recognized under the 1969 Constitution. And these rights were enforceable by an independent judiciary that had the widest possible power of judicial review. We then look at, again, under the Third Republican Constitution. That is the 1979 Republican Constitution. And over there too, rights were also enforceable in an independent judiciary that also had the power of judicial review. Now, the next is for us to discuss the provisions under the 1992 Constitution, which is the current law, as I've mentioned. And our current Constitution, we have a full chapter, chapter 5, starting from Article 1233, that has laid down enforceable human rights provisions. So like I'm saying, it is important that we look at these extensively. And these will be the subjects of our next lecture. We'll be discussing fully the 1992 Constitution and human rights that have been recognized under the 1992 Constitution. So this will be the end of our lecture for this session. Thank you.